Katie Hobbs files a motion for sanctions against Kari Lake. Kari Lake responds, and Judge Thompson issued his opinion. We're going to go through all three today, but Katie Hobbs very upset about this. She said, wait a minute, hold on. How dare you, Kari Lake, challenge me? I'm the Secretary of State. I'm sort of in charge of a lot of this stuff, but I did nothing wrong in running the election of myself. Everything was perfect. Never mind all of the delays on election day. Never mind all of the printer tabulation errors. Never mind what I think is massive voter suppression in the form of people just driving by polling places, never checking in, saying there's long lines, and just being dissuaded from participating. Despite all of those issues, Katie Hobbs says it was perfect. It was excellent. And she was making the argument that Kari Lake was baseless, that these claims, this lawsuit, was done in bad faith. So we're going to see exactly what she says before we look at Kari Lake's response and Judge Thompson's opinion. Let's dive right in. And you'll notice this was filed the day after Christmas, 7:33 a.m. on 12/26, Maricopa County Superior Court. And this was the deadline, right? These people were probably working furiously over the Christmas holiday break. And you'll notice some familiar law firms on this filing. First, Perkins Coie. You remember them. Same law firm that we've talked a lot about here. Remember Michael Sussman? Remember where he worked? Oh, yeah. Perkins Coie. And that was the guy who was interfacing with Jim Baker, who was over at the FBI, who now works at Twitter, or did formerly until he got fired by Elon for being, in my opinion, a little bit dishonest. We also have Abba Khanna. We got Perkins Coie in the house. And guess who else is in the house? The Elias Law Group. Oh, Mark Elias. You're kidding me. Very familiar with him. Guess where he was working? Back during the Michael Sussman saga. Oh yeah, Perkins Coie, right there at that law firm, right? They were sort of in cahoots. And he got called to testify, Mark Elias, at the Michael Sussman trial. We listened to his testimony. Mark Elias, very smart guy, remembers everything. Like an election swordsmith. And I don't mean this jokingly, like the guy's a smart dude. He built a law firm. He is cleaning up Democratic money like a Hoover, right? You know, I would presume, because he's being hired by them. And he's just filing lawsuits left and right. And so he was called in to testify at the Michael Sussman trial. And of course, Michael Sussman didn't testify. And Mark Elias, who's a very, very sharp dude, suddenly couldn't remember anything. Actually was very forgetful during his line of inquiry. So you see he's there from Elias.law. We've also got C. Ford. Christina Ford is also there from the Elias Law Group, along with Elena Rodriguez. Okay, so we've got a bunch of different lawyers, 3 different lawyers at least, 4 from Mark Elias's law firm here. And then you've got another several lawyers, A. Yost, Austin, and Alexis Denneman, 2 from Perkins Coie, along with Daniel Barr. So we've got 7 lawyers, it looks like, just from this short header, if I've counted that correctly. And that's a lot, 7 of them. Whew, I bet that's pretty expensive to get 7 lawyers from New York and DC, all filing on behalf of your clients. Let's see what they asked for. Kari Lake versus Katie Hobbs. You can see this is the governor-elect. Katie Hobbs. Sick. The motion for sanctions and joinder in the Maricopa County Defendant's Memorandum and Points of Authority. So this is her saying, we want sanctions. We know Maricopa County wants sanctions. We're just going to join in their request for sanctions. So they write. On December 24th, Judge, this court, you denied Kari Lake's contest and you entered an order confirming, don't make me say it, confirming the election of Katie Hobbs as the Arizona governor-elect. Oh, gosh. All right, we're just going to keep going. Now, having fully prevailed in this manner, Governor-elect Katie Hobbs, respectfully moves this court for an award of her attorney's fees, right? That's how angry she is. Because she says that these claims were brought without substantial justification. The governor-elect argues Katie is entitled to fees. She says that she joins the memorandum and points of authority and wants motions for sanctions. She says that Kari Lake brought her claims without substantial justification. Never mind everything that we saw here, literally on Election Day. Never mind all of the news stories that the national media was laughing at. And that this unreasonably expanded or delayed the proceedings, and that Kari Lake's claims were groundless and not made in good faith. And they say that sanctions, therefore, are appropriate. Katie Hobbs says that we share the court's sense of urgency in confirming the results of the election, that she won fair and square. Under the circumstances, however, the governor-elect urges the court to direct the entry of a final judgment and confirm the results so that there's no further delay. Hobbs says that considering the compressed schedule on which this matter has proceeded, many of that is, of course, is dictated by law. The statutes say it's got to go from this to this to that. They say, and the urgency in once and for all concluding judicial involvement in the question of the governor's election. They say this is an example of the rare case in which a judgment on the merits would be appropriate prior to the resolution of attorney's fees. They say here in this case, the governor-elect's lawyers will need time to export all the billing records from their electronic timekeeping systems and then fully review all of them. So they're going to go and do an accounting, essentially, of their records. Katie Hobbs says, in the alternative, the governor-elect requests that the court grant her a partial fee application. So they say if the court is inclined to grant Katie Hobbs's motion for sanctions, but disinclined to reserve judgment on the amount of attorney fees to order, the governor submits a partial fee application and supporting declarations based on estimates for this contest. Okay, in other words, she says, we don't know how much we spent on this case, probably a boatload. But if you're going to grant sanctions, we'll give you a rough estimate. I mean, we can ballpark it for you. And the ballpark, is probably going to be close. And if you want to do that, then go ahead and do it. They write, Governor-elect Hobbs retained Elias Law Group, dun, 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 and Perkins Coie. Obvious, because those are the two heavy hitter Democratic law firms in the country to represent her in this contest. And they keep winning. Good move. Both firms instruct their attorneys to enter their time in internal timekeeping systems. In general, at the end of the month, a partner reviews the time entries for accuracy and reasonableness, makes necessary adjustments, and then sends an invoice. Wait a minute. Does that mean that Mark Elias is going to review all of these invoices? I mean, it's his law firm, right? So presumably he's a partner. Maybe, I don't know. Elias Law Group. So all of these attorneys are going to submit their time cards to Mark, and Mark's going to have to decide what to do with it. Well, I think you should have billed a lot more for that one. Neither firm has completed that process for December. And moreover, the compressed timeline between the entrance of the order on December 24 and the deadline for submitting this motion, December 26, has precluded either from doing their full accounting prior to this filing. Nevertheless, we are able to provide an estimate of the total fees as well as the accounting and a subset of those fees that are definite and not subject to adjustment. Here are the estimated fees. Woo, woo. It's a good day for the Elias Law Group. Man, they made some good money on this one. Woo. Estimated fees for additional legal services in connection with this election contest are $550,000. Woo. Of which $457,000 is for the Elias Law Group, as set forth in a declaration, and $93,000 for Perkins Coie. Man, the lawyers are cleaning up on these things. It was a 2-day trial. It was a 2-day trial. There was a bunch of filings and stuff, but that's a pretty good day. All right, what did they have? 4 lawyers on this case? They had 4 lawyers on this case. They worked on this for probably, 2 weeks, 3 weeks. Man, that's a nice chunk of money. Man, okay, it says this estimated fee total represents the adjusted value of the total lawyer and support staff currently entered into the timekeeping system that's later going to be subject to the standard bill review protocol. Yeah, so they really want that check coming over with Kari Lake's name on it for $600 and something thousand bucks. They're asking for a whopper there. Now, they say that definite fees and expenses. They say also fees incurred for lawyer and other staff are $56,000, of which $35,000 goes to the Elias Law Group, another $20,000 to Perkins Coie. They say these are for fixed periods of time. They had 2 hours December 19th, 6.5 hours, and 7.5 hours on the 21st and the 22nd. Those were the days of the trial, obviously. They will also want expenses incurred for their expert witness. Remember Kenneth Mayer. He incurred, wow, he was $22,000 for that day. My goodness. 22 grand for him. We got 4,600 for ballot inspection. And that's it. So a big, nice chunk of money. Of course, all of that signed off on by the Elias Law Group. Abba Khanna, Lalitha Maduri, and Christina Ford, along with Elena Rodriguez. All over there representing contestee Katie Hobbs. They copied Kari Lake's lawyers, obviously, as well as the county. So they want a lot of money. Over $600,000 because they say this election was perfect. And Kari Lake should have never brought it at all. In fact, it was baseless. There was no reason for this at all. And she was delaying the results without any substantial justification, none of it being made in good faith. Well, let's see what Kari Lake says in response to this one. Kari Lake responds to the request for sanctions filed by Katie Hobbs and her lawyers. This one came in 5:00 p.m., 12/26, Maricopa County Superior Court, signed off on by Kurt Olson and Blem Law. This is Kari Lake's corrected response to the defendant's motion for sanctions. Kari Lake versus Katie Hobbs. It says here, this response is to the coordinated filing of 3 motions for sanctions and applications that have come from everybody. We got it from the defendants. We got it from Hobbs. We got it from the Secretary of State in her personal capacity. Thus, for the court's convenience, we're just filing all of this together in one. We're not going to file several responses, one per defendant. So Kari Lake starts. She says, Maricopa County's motion for sanctions and for attorney's fees and the joinder by Katie Hobbs has no basis in law or fact. At issue here is whether or not counsel for plaintiff Kari Lake should be sanctioned, right? Kari Lake's lawyers, for bringing claims that defendants argue are not without substantial justification, but were brought in bad faith and constitute harassment. Lake's lawyers say, though this court found for defendants, Katie Hobbs, on this issue of whether Kari Lake had shown clear and convincing evidence of intentional misconduct, neither the court's findings nor the record support a motion for sanctions. In fact, Arizona law and the record at trial reflect that defendants' motions for sanctions have no basis whatsoever. Moreover, the issues raised before this court were of significant concern to millions of Arizona voters as to the cause of chaos that arose on Election Day and the administration of elections in Maricopa County generally, and Kari Lake's claims deserved to be brought and heard. Lake's lawyers continue. They write specifically, Kari Lake's claims were neither legally groundless nor were they brought in bad faith or for the purposes of harassment, which is what is required under Arizona law in order to justify sanctions. They say Lake's complaint laid out detailed facts and alleged violations of law supported by the sworn testimony of over 200 witnesses, including employees from Maricopa County Tabulation Center and Runbeck Election Services. Now, many of those affidavits and declarations we didn't see or look at here. Some of them were even filed under seal. They also brought the testimony of credentialed experts in electronic voting systems and election voter surveys. We had Richard Barris at People's Pundit. We also had Clay Parikh, who talked about printer scripts having to be rewritten in order to update the printer settings across all of the different tabulators. And internal government documents only recently made public. The complaint from Kari Lake unequivocally identified specific numbers of illegal votes that far exceeded the 17,000 vote margin between Kari Lake and Katie Hobbs. Indeed, they say the court denied Katie Hobbs's motion to dismiss previously. Count 2, the judge said, yeah, there was enough there. That was the illegal tabulator configuration. And that was the idea that somebody somewhere, right, an identifiable person interfered or adjusted, with malfeasance, did something that caused the outcome of the election to be in question. There was also the chain of custody question. This was the idea that there was not proper forms being used and that Runbeck employees were inserting ballots into the chain of custody, literally dropping them into the courier boxes. The judge said, yeah, both of those, actually, there's enough there to state a claim, right? Finding that plaintiff had stated a claim in accordance with Arizona law. So if you can state a claim, if the judge says, yeah, there is actually something here, I'd like to hear the evidence on it, how can you be responsible for sanctions then? If the judge said, there's kind of a little bit here. The other 8 of them got dismissed, but 2 of them moved forward to trial. Lake's lawyers say, that fact alone supports a denial of the motion for sanctions. And while this court ultimately found after trial that Kari Lake had not proven intentional misconduct by clear and convincing evidence, that is a far cry from amounting to sanctionable under Arizona law. Indeed, the testimony at trial exposed facts, which while the court found were not sufficient to show clear and convincing evidence of violation of the election law, nonetheless, it showed defendants' conflicting testimony on issues of Maricopa County and their administration of the elections and their compliance with Arizona law that injured Kari Lake and millions of Arizona voters. Therefore, they say that Hobbs's motion should be denied and no sanctions should be imposed because it's not baseless. It's not in bad faith. The judge said it's good enough to move forward. So the argument begins. Kari Lake's lawyers say, listen, Judge, Katie Hobbs asserts that an awards of attorney's fees is justified under the law. They say that Kari Lake brought these claims, quote, without substantial justification, and that the claims were not made, quote, in good faith. But as demonstrated above, Your Honor, claims were substantiated, they were brought in good faith, and they are a matter of public concern. None of Hobbs's arguments has any merit, nor do Hobbs and her team point to a single case analogous to this case that would justify sanctions and attorney's fees. So they go back, in the record and they say, well, other election lawsuits have been brought. Have they also been sanctioned? Because if they have not, why would they be sanctioned here suddenly? Kari Lake's lawyers give us some case law. They write, there was a high bar for establishing entitlement to sanctions. There's a case from 1998 called Fisher. It says to award sanctions under these statutes, the court must determine that the party's claim hits 3 checkboxes. And we love checkboxes here. We talked a lot about them in this trial. Checkbox 1, whether it constitutes harassment, sanctions. Number 2, whether it's groundless. And number 3, whether it's not made in good faith. All 3 elements, all 3 checkboxes must be shown, and the trial court must make appropriate findings in fact and conclusions of law. Okay, so it's a very high standard. Just like we said, the Kari Lake standard was basically impossibly high, right? She's got to hit the standard of clear and convincing evidence, which is, according to this judge, I would say it's more analogous to like beyond a reasonable doubt, if we're being honest about this, which is a higher standard. But the judge applied the standard as the judge saw fit. And as we went through those check boxes, right, the judge said Kari Lake didn't hit those and they needed to hit them. Here, it's the same concept, but now the government, in fact, the trial court and the party requesting sanctions, they've got to hit the check boxes. So the burden shifts. In the trial, Kari Lake had to prove the claim, right? She was the one responsible for saying this election was fraudulent. Now that it's over, the request for sanctions goes back over to Hobbs. Lake's team, they continue. They say there was a recent case, by the way, that's almost perfectly on point, tells us everything we need to know. In that prior case, the trial court awarded Saul attorney's fees in connection with an abusive process claim. And they found that Goldman's claim was, quote, clearly groundless. Why? Because his position that an absolute privilege applies only to the content of a bar charge, not the act of filing a bar charge, was directly contrary to long-standing and well-established law. All right. So this looks like it's a lawyer filing a complaint, and he did, he's sort of messing up the complaint, and it's a much more clear-cut case. It's a request for sanctions, but it doesn't look like it is actually an election case. The trial court also found that Goldman did not act in good faith because he continued to pursue the abusive process claim on the bar charge after Saul cited binding legal authority that established the claim was meritless. And Goldman even admitted the claim was likely barred as a matter of law. Okay, so they're giving us this compare and contrast. Something we do a lot in the law is we compare and contrast cases and fact patterns. It's kind of like buying a house. You go to a house and you say, why is that house $100,000 more than that house? Well, it's because it's got these extra things on it. Oh, well, that makes sense. And so that's why it cost what it cost. Kind of the same thing here. Well, why did that lawyer have to pay sanctions? Why did it cost him something? Well, because he has these three features. That's expensive for him. Same thing. Here, this lawyer in a prior case, a meritless claim because the opposing counsel cited it for him and it was clear on his face. And he even admitted, he's like, oh yeah, that's a great case. My case is ruined. Thanks for citing that for us. But he probably said something like, I don't care. I'm filing this against you and suing you anyways. Okay, which of course constitutes harassment. They did do a finding of harassment, but they did not find the action was brought solely for the purpose of harassment. And so the Court of Appeals reversed that one, holding that even where an attorney believes where his client's claim is likely barred as a matter of law and a long shot, that sanctions are not appropriate where a party and their attorneys have advanced a thoughtful, well-reasoned, and well-supported position on the law. They say that is exactly the case here. Lawyers are supposed to file. Lawyers are supposed to go out there and throw elbows and get into it. That's the whole purpose of our adversarial system of law. It's a feature, not a bug. Some people will get critical with lawyers. Oh, they're just lawsuit happy, or why if this is frivolous, or this is just a waste of time, or this election stuff. A lot of criticism has been brought on that for the Brunson-Adams case, right? Brunson versus Adams, 22-360, I think it is, in the Supreme Court docket. This is the point of law, right? That's what lawyers do, is litigate and fight over this stuff. You're supposed to file. And so to suddenly just say that any lawyer that files an election claim is now, subject to sanctions because they didn't like the lawsuit or they don't like the claim, what does that do? It chills speech. It dissuades people from filing. It dissuades lawyers from representing losers of elections. And it dissuades losers of elections from filing claims. And it dissuades anybody from keeping close tabs on the elections because they don't want to get hit with the $600,000 sanction if they lose the case. So it's trying to chill this entire arena of law. Why? Because Mark Elias, Perkins Coie, the Democrats already own it. Defendants, they write, misstate this court's order and the record to concoct their sanctions motion, saying that they're sort of manipulating this here and then they're making up justification. They write, Maricopa argues that among Kari Lake's multiple thousands of pages of disclosed exhibits, they say there's not a single piece of evidence that such intentional misconduct directed to affect the outcome of the election had occurred. And, again, This is you can really splice this a number of different ways. People are having a lot of fun with this intentionality phrase. What constitutes intentionality? The judge wanted to see a person with literal intent, okay, direct intent. Somebody who was there on election day said, I hate Kari Lake. I'm going to interfere with these printer settings. I updated the script at this time. That's it, right? That's the bar that the judge wanted. He said so. And we, covered that and said, this is going to be a tough one. But that's what he wanted. Now, other people, you and I, might be able to step back on this thing and use a concept that we often find in tort law called res or re ipsa loquitur, or re ipsa loc, or res ipsa loquitur, however you want to say it, and law school students will beat each other up over this. But re ipsa, the thing speaks for itself. The fact that we had delays in many places for up until 12 o'clock or even in the afternoon, it speaks for itself that there was some sort of misconduct in the election process. Because how else could something be botched so badly on election day? It's gross negligence in a way that really deprecates the legitimacy and the faith in the election, which is the point of all of this. But they carry on. The judge wanted more intentional misconduct. The government says, no, there wasn't any at all. These were all innocent mistakes, man. And we sent people to go fix them. That's evidence that we wanted to remedy the problem. But Kari Lake's lawyers, they say, in fact, the government assertion is itself false. Specifically, despite the court finding that Kari Lake had not sufficiently met the court's standard, in my opinion, a very high standard, the court recognized in its December 24th order that Kari Lake's witnesses did in fact testify and did provide evidence of intent and outcome determinative misconduct. In the order, they said, the court cannot follow Mr. Sonaclair to ascribing intentional misconduct to any party. Now, I think they might be reading the judge's words as saying that there was intentional misconduct, but that it wasn't assigned to any party. They say Barris's analysis also does not have the degree of precision that would provide clear and convincing evidence that the result did change the outcome. They're also referencing Clay Parik's testimony, where he said 19-inch ballot image could not happen accidentally, would be detected by logic and accuracy testing. That came from day one. And Honey testified that the decision to not follow the chain of custody requirements is an intentional decision, right? So decisions to not do things, too, are also intentional. Oh, we didn't test for 19-inch printers. Well, okay. Well, should you have? Maybe, because it turned out to be a problem. Maybe you should have done some additional testing. Maybe you didn't do that intentionally. So that's where we get into this definitional disagreement. The thing speaks for itself. The fact that there were systemic problems across the entire county speaks for itself. Or we need hard, concrete example and evidence, like written in writing of who did it, what time they did it, how many votes specifically that action adjusted. Kari Lake continues. They say that the government in Maricopa, they also cite certain of Kari Lake's Twitter posts for supporting sanctions. Is the FBI working with them now, or what are they doing? First, they say that the defendants, Katie Hobbs, they cite no case law that supports sanctions based on Twitter posts. And they say Kari Lake has a First Amendment right to voice her opinions. And so this criticism must have been in one of the other requests for sanctions, which would have come from the board of directors. We did not see that in Katie Hobbs's original request for sanctions, but remember there were two others, or at least one other. Second, Maricopa seeks to support the motion for sanctions by citing a tweet to an article that was authored by someone else. Her name is at Rach IC. Kari Lake retweeted her tweet. And we're going to read that article a little bit later. Rachel IC, you can follow over here at Rachel IC. She's on Twitter, and she had a great article in Town Hall, which we're going to get to shortly. But Kari Lake, which I retweeted this too. And Kari Lake did as well, because it's a great article. But they want sanctions for that. Lake's lawyers say tweets, especially those authored by others, do not support sanctions under Arizona law. Maricopa also argues that plaintiff unnecessarily expanded these proceedings to include Maricopa County and certain officers as defendants. So Kari Lake named a bunch of additional people in lawsuits. The evidence and the testimony in this proceeding, discussed above and below, shows that the naming of Maricopa County and other officials and defendants was justified. Indeed, evidence came from over 200 sworn declarations, expert testimony, directly on Maricopa County's conduct in the 2020 general election, and it shows that Kari Lake brought these claims in good faith. They carry on. They explain. They say, Judge, in the 2022 general election, Maricopa tabulators were configured to read only a 20-inch ballot image. Prior to this trial, the public did not know that on Election Day, illegally configured 19-inch ballot images were printed on 20-inch ballot paper, thereby rendering thousands of ballots unreadable on the tabulators. Kari Lake cyber expert Clay Parikh came in. He discovered this issue upon examining a sampling of ballots from 6 different Maricopa County vote centers pursuant to the law. Mr. Parikh found that these 19-inch misconfigured ballots existed, quote, at all 6 vote centers, all 6 of them, from which he inspected the ballots, and that the 19-inch ballot issue affected over 42% of the combined spoiled and duplicated ballots that he inspected, and 93% of the duplicated ballots that he inspected. Which makes sense because the duplicated ballots would be the ones duplicated that couldn't be read, and the ones that couldn't be read were the ones that were 42% of the problems because they were printed on the wrong paper. As Clay Parikh testified, Maricopa County did not maintain the duplicated ballots with original ballots as required by law. So there's no way for him to confirm that the duplicate ballot during the inspection was done appropriately. And that came from his transcript at that time. You see they're referencing all of them. They say door 3 ballots refer to more than 17,000 ballots that were rejected by the vote center tabulators as unreasonable, readable, and cordoned off for later tabulation. So they're telling us that door 3 ballots means over 17,000. Over 17,000 is more than the margin of error. It's like 17,117 or something like that. Big numbers there. They write, significantly, Maricopa County Director of Elections, or I would say co-director because he's partners with somebody else over there, Scott Jarrett, he took the witness stand prior to Mr. Parikh's disclosure of these findings. Remember, he was one of the first witnesses. When asked if he knew of any way a 19-inch ballot image could be projected onto 20-inch paper in the 2020 general election, Mr. Jarrett testified, "I'm not aware of it occurring. And I'd be surprised if there was a ballot on a printer that had a 19-inch ballot on it. I'd be surprised." Do we have that testimony? I think we might. Let's see if we can grab that real quickly, because there was a lot to that. And I think we do have it. Right here, as a matter of fact. Let's listen to this fella. Scott Jetter.
If it was printed with a 19-inch image on 20-inch paper and run through the tabulator.
You need to be more specific with your question.
So we talked about the ballot definition. And for the 2022 general election, Maricopa was operating with a 20-inch ballot image, correct?
That's correct.
And the tabulators at the vote center were programmed to accept and read a ballot with a 20-inch image, correct?
That's correct.
What would happen if the ballot on demand printer printed out a 19-inch image on the 20-inch paper and ran it through the tabulator?
We did not specifically test for that because in this specific election, because none of the ballots on our ballot on demand printers had a 19-inch ballot. They all had a 20-inch ballot. So I can answer a question about our testing related to the 20-inch ballot that was installed on all of our ballot on demand printers.
If a 19-inch image was installed, or strike that, if a 19-inch ballot image was printed out on a ballot on demand printer and run through the tabulator that was configured for the 2022 general election,
Right.
would that tabulator accept that ballot or reject it?
Objection, Your Honor. First, this calls for speculation. Second, I think the witness just said he hasn't run that test. I got your objection, speculation. I'm not speaking objection. So, Mr. Chair, if you understood the question.
If you understood the question, you can answer it.
Say that I don't don't know specifically, willing to say that I don't know specifically for this 2020 election. I know based on my historical, or the 2022 election, I know based on my historical knowledge, timing marks on the ballot matter, and it would need to be a 20-inch ballot to run through that tabulation.
Okay, it's pretty important then.
But we did not specifically test a 19-inch ballot through the 2022 tabulation equipment because there were no 19-inch ballot images installed on our ballot on demand printers.
Whoa. But there weren't there? I mean, it was actually printing.
Prior to the 2022 general election, did Maricopa County employ a 19-inch ballot image?
Yes, we did.
And when did Maricopa County employ a 19-inch image just prior to the 2022 general election?
The most recent election would be the August 2022 primary election.
Yeah.
Did Maricopa County perform logic and accuracy testing? Strike that. What evidence exists that shows the results of the logic and accuracy testing?
All right, so that's the line of questioning from the Kari Lake team. They brought him out. He gave that line of testimony. Any way that this could be presented, he said, I'm not aware of it occurring. I'd be surprised if there was a ballot on a printer that had a 19-inch ballot on it. Footnote 5. However, when Mr. Jarrett took the witness stand the next day on behalf of the government, Jarrett testified that just after Election Day, Maricopa County had in fact discovered, wow, that 19-inch ballots were found in 3 vote centers. You're kidding me. That Maricopa County was, one, performing a root cause analysis of this issue. They don't have any answers as to why it happened. Number 2, that Maricopa County had not disclosed this issue to the public, despite the county's public statements downplaying the chaos on Election Day and issuing a detailed written response to the AZ Attorney General's office about the Election Day chaos. None of it mentioned. And the still unexplained existence of these 19-inch ballots found by Mr. Parikh at all 6 vote centers he inspected, which cannot be processed by the tabulators and thus must either be spoiled, require duplication. It violates, among other things, the requirements about logic and accuracy testing designed to ensure that print-on-demand ballots are in fact able to be processed through the tabulators. You got to use the right paper size. Law says so. They also say that Kari Lake's claims show that there were, in fact, good faith chain of custody violation allegations. Here we talk about Stephen Richer, the county recorder. They say that he had conflicting testimony on chain of custody matters. Richer, according to Kari Lake's lawyers, initially testified that the county received so many ballots on Election Day that the ballots are simply processed at MCTEC before being counted at Runbeck because Runbeck has a high-speed counter and there were so many ballot packets. Richer then changed his testimony to say that the ballots are counted at MCTEC and the counts are then documented on chain of custody forms before being transferred to Runbeck where they are counted again. They say that such inconsistency on a material fact like chain of custody supports the claims of Kari Lake, and they also support the idea that this is a matter of public concern. County recorder doesn't even know how it works exactly. In addition, Richer testified that he, as a custodian of Maricopa County in the chain of custody documents, he says that he produced all chain of custody forms with a ballot count for early ballots in response to Kari Lake's request. However, Lake's lawyers say such production did not occur and indeed would be inconsistent with Richer's testimony discussed above. Above that, the early vote ballots are simply processed and then later counted at Runbeck. While the court found that this evidence did not show clear and convincing evidence of intentional misconduct, it clearly is supportive of Kari Lake's claims and it also raises a matter of concern with the public. Such concerns are underscored by the 25,000 ballot increase in the number of ballots reported on November 10th from the day's prior reported total. The magical 25,000 ballots. Poof! Out of nowhere. At the conclusion of the trial, Lake's lawyers say the court stated, the judge said, I'll also say this to everybody that I appreciate. I know this is a highly contested and an emotional issue on both sides, but I want to express my appreciation for counsel for both sides, for your professionalism and your ability to present this case in a way that was thought through, meaningful, and thank you. Right. And the judge did say that. I listened to him say it. And so the judge wouldn't say that if he was unhappy with the case. Plaintiff Kari Lake put forward evidence in good faith that showed substantial support for her claims which also remain of great public concern. Hobbs's motion for sanctions is not supported by case law or the record. Trust in the election process is not furthered by punishing those who bring legitimate claims as Lake did here. And in fact, sanctioning Kari Lake would have the opposite effect. It would. It would show people that this feels like if you even question her or the law or, the outcome, that you're going to be punished. That's not what is useful to our society. We should have people challenging elections. We should have very nicely run elections so that challenges, you just get laughed right out, right? Oh, it's not even a joke. Because it's so perfectly run. It's transparent. We can all see it. It's all open and obvious. This was not that. For the foregoing reasons, they request that the sanctions are denied. Signed by Blem Law, Arizona, and Kurt Olson from D.C. Copying all of Hobbs's lawyers, of course, everybody, for the Maricopa County Board of Directors as well. That's Kari Lake's response. Now, let's take a look at the final decision from the judge. So we had ourselves a quick look at the Hobbs motion. We just also talked about the Kari Lake response motion. And then we're going to see the opinion as well, right after we listen to a word from our sponsors, our friends over at 4patriots.com. My friends, a food shortage could be coming. Even in the United States, experts have written about this as recently as July. Drought, inflation, even new policies are pushing America's food supply near its breaking point. That's why survival food is more important now than ever. And you can create your own stockpile of the best-selling 4Patriot survival food kits ever. This is not ordinary food. We're talking about good for 25 years super survival food, hand-packed right in family-owned facilities in the United States, giving jobs to over 200 Americans. The kits are compact, they're sturdy, they're water-resistant, and they stack easily. They have different delicious breakfast, lunches, and dinners, and you can make these meals in less than 20 minutes. Just add boiling water, simmer, and serve. And right now, you can go to 4patriots.com. Use code Robert to get 10% off your first purchase on anything in the store, including this 3-month survival kit. You'll get their famous guarantee for an entire year after your order, plus free shipping on orders over $97. They're called 4Patriots because a portion of every sale is donated to charities who support our veterans and their families. Go to 4patriots.com. Use code Robert to get 10% off. That's 4patriots.com. Use code Robert. Start building your own stockpile today. Yes, my friends, go over to 4Patriots and get yourself that delicious survival food so that you don't starve to death out there. We certainly want you around for a very long time. And so we are going to continue on. Judge Thompson drafts his opinion. Filed 12/27 at 11:25 a.m., the Honorable Peter Thompson from the Maricopa County Superior Court files this in the case of Kari Lake versus Hobbs. This is the minute entry. This is the decision on the motion for sanctions that was filed by Katie Hobbs. She wanted over $600,000 paid to her from Kari Lake, saying that her complaint was baseless and that it was groundless and it was done in bad faith. Let's see what the judge says. Pending before this court are several motions for sanctions, some submitted by many different people. Motion for sanctions. The judge has said this court has fully considered the arguments, the affidavits, and the memoranda of law, and I have decided. Judge Thompson writes, Katie Hobbs and her defendants, they each seek an award of their attorney's fees pursuant to Arizona law, which mandates that this court make an award if it finds that a complaint has been brought without substantial justification. Substantial justification means that the claim or the defense is groundless and it's not made in good faith. So it's sort of like a math equation. Okay, groundless plus bad faith equals without substantial justification. 1 + 1 = 2. Let's see if the judge finds it. The court agrees with Katie Hobbs' statements that the elections are purely statutory and election contests provide limited forms of relief. Whew, that was scary for a minute. Further, that an election contest presumes the good faith of election officials and that they can draw reasonable presumptions thereafter. The judge said it is also true that Hobbs asked each and every witness at trial if they had either intentionally committed misconduct or knew anyone who had perpetrated intentional misconduct aimed to influence the election. Right? And we saw that. We even commented on that. There was one individual, one lawyer in particular, who made that kind of her closing question. Did you do this? Did you wreck this election? No, I didn't. Do you know anybody else who wrecked this election? No, I don't. Okay, because they were playing that angle with the judge. They were saying that this needs to be an identifiable person, a name and a bucket of votes. The judge says no witness answered in the affirmative. Of course, nobody's going to admit to, multiple felonies. Nevertheless, it's also true that Hobbs alleged in their pleadings, attachments, and exhibits, and even argued at the hearing, that the testimony and the conduct of the election itself, together with statistical analysis, would meet the requirements of the law by convincing and clear evidence. This court does not doubt Kari Lake's belief and her perception of the evidence. However, the analysis of whether Kari Lake's claims were groundless or made in bad faith is not limited to subjective views. Okay, so the judge is saying that it doesn't matter what Kari Lake believes alone. Okay, Kari Lake might believe that, believe everything she says. But even if she does believe it, that's not enough to exonerate her from the possibility of bad faith. The judge says, although 8 of Lake's claims were dismissed as a matter of law, which we read through here, 2 claims did survive, and they did actually go to trial. Granting a hearing on those claims was a question of law, applied to facts and not a benevolent act, says the judge. In other words, I didn't do this just to waste our time. I was trying to test this case to see if there was enough there to go to trial. As a result of the hearing required under the law, Kari Lake's allegations survived dismissal. They were subject to factual and legal scrutiny, and they were ultimately found by this court as failing to meet the certain evidentiary standards, and those ones were tossed. They say that at the hearing, Kari Lake was not successful in eliciting, this is actually at the trial now. At the trial, Kari Lake was not successful in eliciting from any defendant admissions of intentional malfeasance aimed at altering the outcome. However, she did produce testimony of an expert, Clay, which ultimately was not accepted by the court, but who did argue that intentional malfeasance was the root cause of the tabulator malfunctions on election day. That was Clay Parik's testimony, where he said that there was a script that was written to update all of the printers. And the only way to update all of the printers was to get in there and intentionally manipulate the script. You can't do it by accident. Plaintiff also presented statistical analysis based on 220 affidavits of voters who did vote, but reported frustrations with tabulator malfunctions and lines on election day. Lake also presented expert evidence which attempted to establish a relationship between exit polling and results on election day and projected Republican voters who did not actually vote because they were suppressed, they were dissuaded because they heard about all the chaos on that day. I'll go after lunch, I'll go after dinner. I'll vote on the way to my morning meeting. Oh, I can't wait in line for my morning meeting. I'll come back later. You never get around to it. Those people wanted to vote. They were suppressed from voting. They were going to the polling places as a regular part of their day until the government failed. So they were suppressed. And Richard Barris came out and he said, it's really hard to quantify those people. Yes, we can quantify the people who check in, the people who come in and they say, hi, I'm so-and-so, can I vote? They say, no, sorry, you can't. Go wait in line for 2 hours. If they checked in, you can quantify them. But what about the people who just drove right on by, saw the line and said, this is nuts? You can't quantify those people. Richard Barris attempted to, The statistical analysis of polling results also argued a connection between a range of anticipated Republican votes which never materialized, and which Richard Barris testified could have influenced the outcome of the election, trying to check that box. But the judge says that testimony was not accepted because of faulty underpinnings, in fact, unsupported assumptions and foundation. The judge continues and says, the case law regarding election challenges dates back to territorial days, when ballots were counted by hand. There are no cases which rule in or out a statistical analysis as a method for proving elements of an election challenge. So, in other words, you can't do what Richard Barris did. Rule in or rule out. Actually, you could. You could make the argument. But the law makes clear that Kari Lake was required to show a specific number of votes affected, which would impact the election outcome, right? An identifiable bucket, a hard number. The court was not persuaded that, among other failures of proof, statistical analysis with projected range of votes based on assumptions as to people who did not vote met the burden of clear and convincing evidence, requiring a specific number of votes to be added or subtracted. This ruling is not an exhaustive recitation of the basis for that ruling. The court refers the parties to that ruling if you want to know why I ruled that way. The judge says, there is no doubt in this case that each side believes firmly in its position with great conviction. The fact that Kari Lake failed to meet the burden of clear and convincing evidence required for each element does not equate to a finding that her claims were or were not groundless or presented in bad faith. Any legal decision must be based on the law and facts rather than subjective or partisan opinions, no matter how strongly held. The court has heard all the evidence and the arguments. The court has carefully examined and thought through the facts and the evidence before, in the motions, and at the hearings. And so, accordingly, the court finds that Kari Lake's claims presented in this litigation were not groundless, were not brought in bad faith under the law. Therefore, it is ordered denying Katie Hobbs's motion for attorney's fees and sanctions. Sorry, Mark. Kari Lake's not paying your bill there, buddy boy. Assessment of taxable costs. Says a prevailing party in Superior Court is entitled to an award of taxable costs. And so Secretary of State Katie Hobbs has presented her request for $5,900. They hired expert witness Ryan Macias, the dude who some people think was reading from the screen when he testified on Zoom, who was retained as an expert, testified at a hearing. A separate request is for expert witness fees in the amount of $22,000 was submitted by Katie Hobbs. Defendants have not submitted any other court fees. So the court finds that the submitted expert witness fees are appropriate. So Kari Lake's going to have to cough up $22,000 plus $5,900. Katie Hobbs sued in her capacity, also submitted a signed declaration of an attorney, ABBA. They want $4,600 for Maxwell Schechter, the person designated by them to be present at the inspection of the ballots. So he wanted $4,600 for that. Compensation, he signed, he's $565 per hour, 8.3 hours in the inspection. Woo. Although he did not testify at trial, the choice of the defendants to employ him was based upon qualifications, and he was the opposition to Mr. Clay Parikh. The court finds that the compensation for that is appropriate. $5,900 is awarded to Secretary of State Hobbs. Governor-elect also gets $22,000 taxable costs, also gets $4,600 as compensation for her inspector. It's ordered that the amounts entered with this judgment shall run with an annual interest rate 7.5% per annum. The court having entered now its findings of fact, conclusions of law, and orders on December 24th, and all matters, this court having been resolved, nothing else pending, it is hereby ordered confirming the election of Katie Hobbs as Arizona governor-elect pursuant to the law and entering a final judgment in this matter dated December 27th, 2022. Gross. All right. So that all, of course, signed off by the very honorable Peter A. Thompson. Yucky to hear that, but what can we do? Appeal. Kari Lake has already done that, in fact. And shout out to our friend John McGarvey over on Locals, who already linked us up with what I thought might happen today, which is Kari Lake's notice of appeal hits the docket. And in fact, you can see it right here. And let's see. Yeah, it's just the notice of appeal. Very, very quick filing. So let's go through this in some detail as soon as we can get the red pen out so we can properly mark this up. Kari Lake files her notice of appeal. This one hits the docket 12/27, 3:59 p.m. filed by her lawyers Blem Law and Kurt Olson. We've got Kari Lake versus Katie Hobbs. The appeal here already. Plaintiff Kari Lake hereby provides her notice of appeal pursuant to Arizona law. And the way this works in Arizona and many other states is you got to file your notice of appeal first. It's just a notice. It's just saying, okay, we've got a whole stinking appeal coming. Brace yourselves. And so you have to file this quickly. Then you have a lot more time to file a much more substantive motion after you've gone through the transcripts and you analyze the different facets of the law. But let's see what the notice tells us. Kari Lake provides her notice of appeal. This is the caption. She says the special action is captioned as Kari Lake personally versus Katie Hobbs in a number of different capacities. Also involves Stephen Richer, Onesie Twosie, Bill Gates, Jack Seller, and others. We know we've got Scott Jarrett is on there, along with other from the Maricopa County Board of Supervisors. The case number is 095403, Maricopa County Superior Court. Plaintiff Kari Lake takes this appeal. What specifically, Kari, are you appealing? Here, she says, this is the final judgment entered December 27th that denied all of Lake's requested relief and dismissed the case. Incorporated into the judgment from the appeal are the granting of the motions to dismiss of counts 2 and counts 4. Those were the 2 remaining counts that proceeded to the trial or the hearing. Plaintiff appeals to the Division 1 of Arizona Court of Appeals. Plaintiff will also seek direct review from the Arizona Supreme Court as well. Signed by Brian James Blem, Kari Lake's lawyers, all filed and copied to the Elias Law Group and everybody over at Perkins Coie, making sure they're all well aware of it. So they've got the Exhibit A, which is the minute entry, which was just recently filed. This is the one that we just read through, and they've got the rest of the case file attached just for the record. All of that now being submitted to the Arizona Court of Appeals, Division 1. Of course, we will continue to follow as these appeals work their way through the courts. And Kari Lake promised to appeal. Of course, that has happened. Some people were wondering, myself included, as to whether she would continue to appeal after there was a request for sanctions. You know, if there was no sanctions or no penalties, would she still appeal it? Of course she is. And we'll see where this goes. You know, I don't know that she's going to get a different outcome just because it's an election case. And as we've covered here, my friends, there have been so many election cases that we've covered that have been appealed. None of them had any merit. By the time this gets its way up to the Division 1 in Arizona, Katie Hobbs, my understanding, is already going to be ensconced in power. We'll see if anything happens. We'll stay optimistic. Hopefully, Arizona can be saved. But we'll continue to cover, of course.